Hello friends, my name is Dr. Jigisha Singh and in this video I'm going to discuss cases on frustration of contract and contingent contracts. The first case is Satya Brata Ghosh versus Mugneeram, Bangur and Company. Well, the citation is 1954 SCR 310. Well, it is plaintiff versus defendant, agreement to sell land at a future date. Plaintiff won in the lower court, plaintiff lost in the high court, and plaintiff won in the Supreme Court. D. The company, owner of a huge area of land in the city of Calcutta before independence. The company decided to develop land for residential purposes to cut plots of different sizes. The plaintiff applied for purchase of one plot of land. Agreement was entered into writing. On 15th August 1940, the contract was entered when the World War was already on, World War II 1939. Parties aware of the natural consequences of war deduced no fixed time for completion of roads and drainage. Terms and conditions. The company shall construct road and drainage system so as to make the place suitable for residential purposes. The purchaser were supposed to give 101 as token money or earnest money. As soon as the work is complete, the purchaser shall tender the whole amount of consideration and then the sale deed be executed. Under contract, the purchaser would be required to render whole consideration only after construction of roads and drainage is complete and not before that. On 12 November 1941, the government of Calcutta acquired the land for a temporary period. Work cannot be carried out due to the acquisition. Moreover, between 5th August 1940 to 12th November 1941, more than 1 year, the company did not at all start the construction of roads and drainage, and it was uncertain when the land is going to be released. In 1943, the defendant company wrote a letter to all the purchasers regarding acquisition of land by government, and it is difficult in starting the construction, and that every purchaser must render the whole consideration within 1 month. Such terms written in the letter amounted to a unilaterally changing the terms and conditions of the contract, and what tends to violation of contract. The company gave an opinion the company gave an option that those who cannot make the payment can ask for return of earnest money. P, after receiving the letter from D, did not accept either of the two conditions. P wrote a letter to D that he would pay the whole amount of consideration only after the completion of the work, that is, roads and drainage. The company D, after receiving the letter of P, cancelled the contract of P and did not even refund the security deposit earnest money, and D can cancel the allotment. P suffered damages and filed a suit for actual performance of the contract. Plaintiff's first argument: contract is still in existence. There cannot be any unilateral change in the terms and conditions. When suit was filed in the Supreme Court, the defendant argued because of temporary acquisition of land by government, there is frustration of contract and contract is rendered void, and there is no question of paying damages and no question of keeping contract alive. In this case, there was a contract in which no time limit was specified regarding completion of construction of roads or drainage, no time period in the contract. This deduced the fact that both the parties had the knowledge and contemplation of the fact that during war there is unusual rise in the prices. Cement, iron, acquisition of land by government is also a normal activity by government during such circumstances. Therefore, parties did not mention the limit, assuming that work may be completed but delay may be possible. Consequences were in the knowledge of both the parties. P argued that the doctrine of frustration as applicable in UK does not apply to India. Section 56 contains a specific provision, and no frustration provision must be applied in the light of Section 56, and therefore court should not follow the doctrine of frustration as in UK. In UK, doctrine of frustration includes both physical as well as practical frustration of contract. Plaintiff said Section 56 only talks of practical impossibility and not physical. Physical performance is possible, yes, possibly through some delay. Company argued, from practical point of view, saying performance has become useless. Section 56 concerns only physical impossibility and not practical impossibility. Argument rejected. Supreme Court held, where a statute at a given point expressly gives specific law, then the law of UK is not applicable. And the court decided, according to the language of the statute, that Section 56 talks about both physical and practical impossibility. Section 56 covers both physical and practical frustration of the contract, and court said the language of 56 can be interpreted as wide enough to cover both physical and practical frustration of contract. First part accepted, second part rejected. Now the second argument was doctrine of frustration does not apply to agreement to sale of land. In UK, conduct of the Council of P. Clever. When the law of UK suits him, he argues for, and when it does not suit him, he argues against. Doctrine of frustration does not apply to completed contracts as in UK. Since the contract is complete between the seller and the buyer, no question of frustration. In UK, ownership of two types, legal and equitable. In India, there is only legal and no concept of equitable. Example, A sells to B, and after the agreement, government acquires the property. Now, according to the principle of UK, B can claim damages in compensation from the government, who is the purchaser, and not A, who is the seller, since B is now the owner of the property by virtue of equitable ownership. Section 54 Transfer of Property Act expressly says it does not confer any right in the purchaser after entering into an agreement to sell a land. Contract is yet to be performed. Supreme Court decided in different provision law. It is not applicable in UK but shall apply in India. Argument was rejected. The third argument was on actual fact of the case. There is no frustration of contract. Temporary acquisition result in frustration of contract as per language. Argument accepted. Whether on actual facts of the case there was frustration. Section 56, company bringing a new contract altogether. The terms in the letter will only amount to contract to those who accept it. Otherwise, it would amount to changing the terms unilaterally and amounting to breach for those who do not consent for the new condition. If the event causing the frustration is in the contemplation of the parties, it does not amount to frustration. Land has been temporarily acquired, even event of world war in the knowledge of the parties, no question of frustration. Parties foresee or where which ought to be. In case of breach, parties must pay compensation. Acquisition of land, it is a normal event and can easily be foreseen in a situation of war, and no time limit for the completion of construction of roads and drainage. It was done knowingly, deliberately. Had there been any date for completion of construction of roads and drainage, it would have amounted to frustration of contract. During war, shortage of iron, cement, normal, and it is in the knowledge. Cement, iron, and it is in the knowledge. So 5th August 1940 to 12th November 1941, company did not start construction. Temporary change in law or government intervention may or may not amount to frustration. It depends on the facts of the case. Permanent action, always frustration. So it was held that the contract was not frustrated under Section 56 of the Indian Contract Act 1872. Despite delay caused by wartime requisition of land, the court clarified that Indian law on frustration is broader than English law and depends on whether performance becomes impossible or impracticable in the light of contract's purpose. The next case is Alopi Prasad and Sons Limited versus Union of India. Citation is 19602 SCR 793. Now, this is the case that regards frustration and plaintiff versus defendant, two agreements between parties, First agreement entered on 1st October 1937 before World War. Supply of desi ghee to the government for use of armed forces. Terms and conditions reduced in writing. 1939 Second World War start. There was shortage of desi ghee, increase in prices. Performance by P to provide government D with desi ghee became unprofitable at the old prices. So P made requisition to the government that an old agreement should be revised and new terms and conditions should be added, increasing in old prices. After this, there was a continuous increase in the prices of desi ghee, and at revised price also business became unprofitable. P wrote a letter on 8th December 1943. Due to World War, prices continue to rise. World War, there was again prices should be revised. To this letter, government did not respond in writing. Therefore, government replied. Therefore, government replied that at the point of time, the P should perform the contract and must cooperate, and government should compensate him later. Though the terms, through the terms, the government had power to cancel the contract. Ultimately, the government legally cancelled the agreement. After cancellation, P demanded compensation from 6 December 1943 to May 1945 at increased prices or orally agreed. Government refused to pay at the increased prices. P filed a suit. P performed the contract on the assurance given to him by the government to the contract that they will compensate, whether P succeed or not. P argued, when increase in prices, it amounts to frustration, no contract, it is void. Parties continue to perform the contract, they can claim compensation on quantum merit. It means compensation which court thinks just and fair in the given circumstances. When contract is void and still performs the contract, court is available with the concept of quantum merit. P demanded compensation on the basis of quantum merit. Cause of frustration, World War 1939. When second agreement was entered, on the basis of second agreement, the parties were aware of war and would foresee and continuous increase in prices, and so the plaintiff should have made a new clause so as to protect him from the further increase in prices, if any. The plaintiff did not do so. He did not make a clause. When event causing frustration in the knowledge of the parties, it does not amount to frustration even if it does not take into consideration this argument and ignore it. On the facts of the case, there was no frustration. 6th December 1943, in spite of incurring heavy loss, P did perform the contract, though performance physically possible. And such circumstances are continuous increase in prices do not amount to frustration as they are commercial hardships, and commercial hardships not a ground for frustration of contract. Again, such situation was in the knowledge of the plaintiff, held no frustration, and contract continued to be valid. Plaintiff can claim payment on the price agreed to the parties. The Supreme Court held that contracts cannot be altered or discharged merely because performance has become more onerous or unprofitable due to changed circumstances like wartime inflation. The court emphasized that parties are bound to express terms of the agreement, and equitable considerations such as fairness and hardship cannot override contractual obligation. The next case is Ganga Saran versus Ram Charan Ram Gopal. The citation is 1952 SCR 36. It involves contingent contracts and frustration of contract. P argued that there was a contingent contract by virtue of the terms and conditions and the contract became void. And if it is not contingent contract, section 32, then contract has become frustrated under section 56. It was plaintiff versus defendant. Defendant supplier of the cloth of P and P is the purchaser. Agreement in writing. Now D agreed to sell cloth manufactured by Victoria Mills by a certain date. Agreement provided that D shall supply as soon as he receives the supply from Victoria Mills. Now, the point of interpretation of the clause was as soon as. What does as soon as signify? It meant that there shall be delay on the part of D. It meant that there shall be no delay on the part of D. On the facts of the case, the plaintiff failed to supply the cloth to P, as cloth was not supplied by the mill to the D. D failed to perform the contract. P suffered losses and files a suit. D argued contingent contract. He said the condition of the contract was that D shall supply only if he receives supply from the Victoria Mills, and if D does not receive them, contract stands void due to contingency by virtue of the clause as soon as. Job of the court was to interpret the clauses as soon as and not to add to it. The court said that the words as soon as in the clause are different from only if. Only if and amounts to changing the interpretation of the clause and adding new terms of the contract. In the light of the words as soon as, it said that D did not intend any delay on the part of the supply of cloth to P. These words only save the impression, no delay, and that supply to P by D totally depends on the supply made by Victoria Mills to D. When the trader enters into an agreement by virtue of his experience and could foresee that in some situations the supply by mills may not be possible, and when such event is in the knowledge of the trader or ought to be in the knowledge of the trader, actual or constructive, it does not amount to frustration, as it is normal event that in some occasion mill not in a position to supply cloth. Now D did not at all place any order on the Victoria Mills, where the event responsible for the frustration is self-induced by action or non-action. It does not amount to frustration, and D is himself responsible. Whether contract contingent or not, it will depend on the language used in the contract. Well, the Supreme Court of India clarified the scope of the doctrine of frustration under Section 56 of the Indian Contract Act 1872. The court held that a contract is not frustrated merely because performance has become difficult or commercially inconvenient. Frustration applies only when performance becomes impossible or unlawful due to circumstances beyond parties' control. The next case is Nehati Jute Mills versus Khayali Ram Jagannath, AIR 1968 SC 552. It is P versus defendant. P is the purchaser, defendant is the seller, the importer. Supreme Court judgment, agreement in writing. D agreed to import cotton from Pakistan to P for during 1 year. For import license is essential. In agreement, it was stated it will be the duty of P to obtain the license and give it to D. If P unable to obtain the license, then he shall pay the damages to D. The term may be the grant of license, a responsibility with P. At the time of entering into agreement, both the parties were aware that the fact that there are 50-50 chances of getting license. Agreement provided on a suggestion by D. If license was not granted, P shall pay damages to D. This suggestion P was free to accept or reject. In spite, he agreed to it. Now, knowing that license may or may not be granted, and in case it is not granted, he shall be liable to pay damages to D. P could not obtain the license. He was required to pay damages, and there was no frustration of contract. P argued when amounting to frustration not obtaining the license, it was held that P should have protected himself, and saying that in case he is unable to obtain the license, he will not be entitled to pay damages, but he did not do so. The Supreme Court decided that where the event causing frustration was in the knowledge on actual or constructive of the parties, and in spite of that one party agrees to perform or pay damages, there is no frustration of the contract and the party must perform the contract by paying damages. This was the position of law both in UK and India. Where there are persons with full eyes open agrees to increase to impossibility of performance, he shall either perform or pay damages. The next case is Raja Dhruv Dev Chand versus Raja Harmohinder Singh, AIR 1968 SC 1024. Under an agreement in writing, P took land from D on lease or rent for the year 1947 to 48. The whole amount of rent was paid in advance by P to the D. There was the partition of land, and after partition the land in question was allotted allotted to Pakistan, and after partition, P planned to migrate to India. Now P was not in a position to use or enjoy the land. In this situation, P demanded the refund of the amount, the balance amount. D refused to pay refund the amount, saying that I am still the owner of the land and it is not my fault, it is P's fault. P said that he should refund because I am unable to use or enjoy the land. It is D's fault and not his. P argued that by virtue of partition of India, the contract stands frustrated and P is liable to get refund under Section 65 of the Indian Contract Act 1872. This section is applicable only when contract stands frustrated. Question was, excuse me. Question was whether the contract stands frustrated. Once the contract was duly entered, possession of the land was given to P. Full consideration amount was paid by P to defendant. It means that the contract was fully performed and nothing was left to be done. In such a situation where contracts are fully performed, that is, doctrine of frustration does not apply to completed contracts. Again, D should have argued that frustration was self-induced. D continued to be the owner of the land and it was P who voluntarily planned to migrate to India. And again, as far as enjoyment and use of land is concerned, it could have been done by P through any agent of P in Pakistan, but he did not do so. He did not perform that. In such a situation, there is no frustration, thus no question of refund under Section 65 of the Indian Contract Act 1872. The next case is VIN Narasu versus PVS Iyer, defendant versus plaintiff. Defendant is owner of the cinema hall, plaintiff is producer of a film. Now dates material are 31st August 1946, 5th December 1946 and year material is 1948. Under an agreement entered into 31st August 1946, under an agreement, D agreed to exhibit the film of P till weekly collections fall below 3600. From 31st August 1946 to 5th December 1946, the film was exhibited continuously as agreed and weekly collection was above 3600. On the later date, the wall of the cinema hall collapsed during rain and the cinema hall was rendered unfit for exhibition of the film. For exhibiting the film, first license had to be obtained from police. It is mandatory for cinema hall. The license for exhibition is valid for 6 months after the building inspected by the police official, and if the building is found fit for exhibition, then the license is again renewed, and if the building is found dangerous, license is cancelled. There are two questions of law: whether there was frustration or not, whether frustration self-induced. The question of self-induced frustration arose because D constructed the building afresh and completed the contract in 1948. P said reconstructed the cinema hall and exhibited other films. P said that now D is in a condition to exhibit the film again till weekly collection falls below 3600. From 5th December 1946 to 48, he said he is in a position to perform the contract. Now when he is in a position to perform the contract, he should exhibit his movie. It is said that can it be taken a fault of D that he has reconstructed the cinema hall? Had he not reconstructed the cinema hall, he contract would have stood frustrated. D said that he was not under any legal compulsion to construct a building. B was free to construct or not to construct. D was not entitled to construct the cinema hall legally, under no legal obligation under the contract to construct. So having constructed, can P take the advantage of a contract for which D was not entitled, to which P never entered? In 1948, performance was physically possible, but keeping in mind the purpose object, performance was become useless. Practical frustration. If because the change in circumstances a totally new contract comes into picture, which the parties never intended to enter into, it is always practical frustration of the contract. Test applied for practical impossibility or frustration of object. Fundamental change in the circumstances striking at the very root of the contract. Can a court compel a party to perform which the party never intended to? No. Two important facts which D contended. Nature of the cinema hall: old cinema hall, less rent; new cinema hall, more rent for the owner. Film: new, more payments to producer; old, less payment to producer. D argued that in 1946, I entered into an agreement to exhibit a film in a building which was old and the film was new. Now, the situation is different. It is a new building and an old film. Such a contract was never entered into. Argument agreed. Year 1948, frustration, though physical performance was possible. P argued that the frustration was self-induced. He argued that the building collapsed because of the negligence on the part of D, the owner. The D said that the license is issued to him by an authority and he got the building inspected by the official who did not find any defect in the building and the renewal of my license, and so the defects were latent. Had the defect been patent, the officials could have come across and cancelled the license, and moreover, for such defects, D was liable to get them maintained and repaired. D said, since the defect latent, it is not his liability. D inspected from the police, from the competent authority. Defects patent, defendant liable. Defects latent, defendant not liable. No question of self-induced frustration. Court pointed out that even if D is guilty of negligence, still there is no self-induced frustration. Only new point laid down by Supreme Court. Reason for this argument: negligence can be a ground for self-induced frustration only if negligence was with the sole object of causing frustration of the contract, voluntarily deliberate. Where the D is guilty of negligence, however, though he was negligent, he never intended for frustration of contract. It cannot be the ground for self-induced frustration. Two important points must be fulfilled: negligence plus negligence with the sole object of causing frustration. Now, even though the defendant is negligent, it cannot be said that he did it with the sole object of causing frustration, since the owner of the cinema hall had at time was earning good profits. So why would it be in a situation would cause frustration? There was no temptation to cause frustration of the contract. Even if D guilty of negligence, it is not a case of self-induced frustration. Now, the Madras High Court held that the contract was frustrated under Section 56 of the Indian Contract Act because the cinema hall where plaintiff's film was to be screened collapsed due to heavy rains and latent defects making performance impossible. The court discharged the defendant from liability, emphasizing the frustration applies when unforeseen events destroy the very foundation of the contract. With this, I conclude. In the next lecture, I would be discussing on breach of contract.